She used my name to get a $100,000 loan. She didn't know who she'd stolen from. People in my family had long since settled into their versions of me. I was the quiet one, the son who kept regular hours, never drew attention, the one who didn't inherit the loud ambition or the appetite for display. I let them think I was small. It made family dinners easier, kept my mother from worrying, kept my father from asking uncomfortable questions. It also kept me safe. That safety was twofold. There's the ordinary kind, avoidance of family drama, and then there's professional safety, the camouflage I'd cultivated as a matter of trade. For most of my adult life, I walked a parallel existence. At home, I was Marcus, the modest accountant at a municipal firm who fixed his own leaky faucet. At work, I was Senior Special Agent Marcus Chin, Financial Crimes Enforcement Network, sworn to follow the paper, trace the money, and leave no ledger untouched. You learn quickly in this work that people reveal everything in plain sight. Small inconsistencies become threads: a sudden inquiry on a credit report, a late payment indexed to an address you've never lived at, a notarized signature that flattens under comparison. Most of the time, these threads are anonymous. A fraudulent card here, a synthetic identity there, and you stitch them back into order with subpoenas, forensic accounting, and patience. When the fabric of fraud intersects with family, the stitches are tighter, the choices uglier. If you've seen the car I drive, an older Honda with a dent on the rear bumper, you'd laugh at the idea that I could be of any consequence. It's a deliberate choice. When we work financial crimes, the best cover is to look unremarkable. Banks, victims, and perpetrators treat you differently when you appear ordinary. In the field, we are trained to be invisible until we choose otherwise. The estate planning meeting began as estate planning meetings do. Polite smiles, coffee cups, the clink of bone china. My parents had insisted on a Sunday that felt like a ritual, folding the house's future into neat lines on paper. My sister, Jennifer, known to everyone as Marie, arrived in a lacquered denial of subtlety. A new Mercedes idled in the cul-de-sac, a signature perfume announcing her passage before she came through the front door. She wore a dress that cost as much as my monthly mortgage, and a laugh loud enough to shape the afternoon. Jennifer had been good at playing success. She had always been the family's demonstration piece. Promotions, designer handbags, the Instagram-ready life. The difference between her display and the accounts she kept was what would become the fulcrum of the evening. She loved the stage of family gatherings. She loved the audience. I had begun to notice her showpieces in a different way about 6 months before the estate planning meeting. My work had nothing to do with my family. By policy, I kept professional and personal lines separate, took pains to avoid conflicts of interest. But I do what we all do in this line when a name overlaps with a case. I looked. Not as an investigator on the clock, but like anyone else, I checked my own credit. Sometimes professional instinct is indistinguishable from personal curiosity. At first it was a few anomalies, an inquiry here, an odd address there. They were the sorts of quiet breadcrumbs that would not alarm someone without context. In my job, those breadcrumbs are evidence. I tracked them. A hard inquiry from a lender I didn't recognize. A balance owing on an account I never opened. Mail listed to an address I never lived at. Each item, when pulled into a line item report, began to suggest intent. I didn't confront Jennifer then. There's a method to that silence. You don't tip your hand at the first sign. Evidence has to be airtight. A sequence of applications, the forged signatures, the routing numbers, the loan proceeds traced out of the accounts. Emotional confrontation risks the loss of documents, the deletion of digital traces, a family member's sudden move to liquidate or hide assets. You wait. You document. You follow the money. Which is why that Sunday felt like a trap, even before Jennifer started speaking. She had been unusually talkative during dinner, narrating a recent business move, pleased to demonstrate how clever she had been in securing financing for a new venture. The family leaned in, my parents beaming, Uncle Ray gruff with curiosity, Aunt pushing her glasses down to see more clearly. They wanted details, and she supplied them with nothing but bravado. "And then they approved it," she said, playing with the stem of her wine glass, "without any trouble. I told them it was my sister's name as a reference, and they barely blinked. It was an old credit on file. I used it to get the loan. 100,000. Can you imagine?" Her voice held applause. The table laughed. My mother reached for her hand in a way that made my chest tighten, proud and oblivious. The way Jennifer said it, so casual, so triumphant, sounded like a confession to someone trained to hear confessions between the lines. I put down my fork. The lace tablecloth, the candlelight, the porcelain plates. Every small domestic detail seemed suddenly at odds with the word loan, with used my sister's name. I felt the air change. My father's fork paused midair. Uncle Ray's face hardened. The room found that strange pause where everyone waits to see whether the joke will land. In most families, theft is the thing you whisper about in the hours after dinner, while someone goes to the store for more wine. In my family, the whisper was swallowed by the moment, because the person who had been stolen from was sitting at the head of the table. I kept my voice even. "You used my name?" Jennifer grinned without humor. "It was easy. They required a reference. I gave them you. Everything cleared fast. I mean, why would they check? Everyone knows you're dependable. You pay your bills on time." Her comment landed like a plate. The factual wrongness of it, your identity used without your permission, your credit risked, spoke louder than any accusation. There was no immediate denial of intent. She framed it as a clever workaround, a small moral flexibility that, in her telling, had no victims. No, I felt the familiar professional apparatus engage, measure reaction, register statements, preserve scene integrity. When someone admits to using another person's name to secure funds, that admission is evidence, sometimes as valuable as a signed affidavit. But people unwisely confess when comfortable and boastful. The confession itself is not the end. It is the opening note of a ledger you intend to close. My first move was small and unobtrusive. I excused myself to the kitchen under the pretext of a dish that needed attending, slid my phone out, and pulled up my credit history. The hard inquiry was there. The loan application date matched a dinner date months earlier when Jennifer had claimed the action had taken place. The lender's name appeared. The account number was visible in the preliminary view. Missed payments had begun to show up, generating late fees that had been posted to the credit file. A red flag in any investigation is a string of late payments, especially when they suggest that the borrower is not the person listed in the application. I wasn't always proud of how quiet I had learned to be in moments like that. It's a paradox in law enforcement. We are trained to act, but we are also trained to preserve. If you blurt accusations at a dinner table, you risk losing the documentary trail. If you pounce, you risk your subject fleeing with the very phone or laptop that contains the admissions you need. You wait, you obtain warrants if necessary, you create a legal capture that cannot be unstitched by tears or family pleas. So I did what I would do in any case. I photographed the inquiry screen, time-stamped the image, and began to compile a record. I made notes: who was present, what was said, how Jennifer framed the act. All of it would be relevant. The moment remained volatile, and the household a potential crime scene. That dining room would become a place where evidence had been uttered aloud, and spoken evidence can be as decisive as the signature on a falsified application. My mother, oblivious to the mechanics of credit reports, asked a question that widened the silence. "Did you ask her if she'd paid it back?" she said, looking at Jennifer with worry. Jennifer waved it away with the ease of someone who believed she could smooth any problem with charm. "I'll pay it back, sure. It's just a temporary bridge. Besides, you know Marcus. He's always been stable. He won't even notice. That last phrase was what set a kind of clinching cold in my gut. Underestimate me at your peril, I thought. The joke was on her. I returned to the table with a composed face. In public, I am practiced in neutral expression. In private, the machine of my professional mind whirred. There are lines you cannot cross without consequence, and identity theft is among those lines. Federal statutes exist precisely because these violations harm credit, livelihoods, and futures. A $100,000 loan is not pocket change. It is life-altering and, if unaccounted for, transformative to a family's financial landscape. I watched Jennifer move through the room, easily deflecting questions with anecdotes and small performances. When a niece tugged at her sleeve demanding a story, she made a show of finessing a familial moment. The contrast between her carefully constructed persona and the registrable harm she described was jarring. The question that occupied me most was not whether she had the audacity to use my name. The question was whether anyone else had been touched by the same pattern. Identity theft tends to scale. One fraudulent loan can be an anomaly. A series points to a system. My training told me to assume pattern until proven otherwise. I decided to initiate a precautionary step. Not an arrest, far from it, but a controlled escalation. Internal protocols required me to disclose any personal connection and recuse myself from direct investigative work. But the first moments, before any formal recusal, involved documenting contemporaneous statements and securing evidence while a subject remains on site and potentially consents to searches or to producing documents. I stepped back into the kitchen and called a number only a few people in the agency had. "Karen," I said to Deputy Director Martinez in the voice I reserve for operations-related calls, "I need to consult. There are admissions at a family gathering implicating me as the identified victim." Her reply was immediate and measured. "Do you have evidence in front of you?" "Yes," I said, "but I'm in the field, family field. I need a team to evaluate options for on-site response. I will formally recuse, but I need protective action now. There's an active admission of using my identity to secure financing, $100,000. In this telling, I'm using $100,000 as the central figure for the loan. I want an agent to document the scene, interview witnesses, and preserve digital artifacts. If consent is given, we can obtain devices. If not, we'll move to warrants." There was a pause, the professional kind. "Keep it contained. Notify the local FBI liaison. We'll assign a lead. Coordinate with U.S. Attorney's Office if necessary. Don't confront. Preserve the scene. And Marcus, document everything. You know the ethics. You recuse. We'll take over operationally." Her voice was procedural and somehow kind. The moment of personal exposure did not eradicate institutional process. It reinforced that my role was to supply truth, not to be the vengeful force in a family dispute. After I hung up, I re-entered the dining room with a calm I did not feel. I let the conversation drift back into safe territory. Football scores, weather, an old political joke no one should have found funny. Meanwhile, I had arranged for 2 plainclothes agents to meet me at the back of the property within the hour, under the guise of being neighbors who had come to borrow sugar. Practical, unobtrusive. The last thing you want is the accused to delete a phone or remove documents because a uniform appears in the doorway. Before the agents arrived, I took a more direct approach. I asked Jennifer if she would show me the application, the lender's correspondence, anything that would substantiate what she'd said. She laughed and handed me her phone as if it were a prop. On the screen was a screenshot of a loan approval page, a bank logo, numbers blurred by a digital crop. The key elements were visible. My name listed as a reference, the loan amount highlighted, $100,000, and an approval date that matched the hard inquiry I had found earlier. When I scrolled through the messages on her phone, she was cavalier. She joked with the contact about the easy paperwork, and she sent a photograph of a wire confirmation, although the confirmation itself, when inspected, was a generic notification, not the bank-level detail you would want for legal proof. It was the kind of evidence a perpetrator might keep for bragging, but not in a way that could stand alone in court. That is where a forensic collection comes in. Digital breadcrumbs remain even when the proud selfies and boastful texts are deleted, but only if you move with the right tools and the right legal authority. The minute the agents arrived, the living room felt smaller. 2 men in plain clothes, 1 woman with a neutral haircut, none of them obvious. They circulated the house politely, introduced themselves in tones designed to disarm. The agency protocol I followed, because the situation implicated me directly, was to step out of the lead role immediately and allow a neutral team to take over. I would document what I had observed, provide my contemporaneous notes, and formally file a recusal. For now, however, I stayed in a shadow, an observer to the transition of family hearth to operational site. Jennifer's demeanor flickered once when the second agent asked about supporting documents. There was a flash like an animal checking a closed door. My mother clasped her hands. Nobody understood the full weight of what was unfolding, but everyone felt that something fundamental had shifted. Consent matters. We asked for it. We never forced it without legal grounds. Jennifer, flushed with bravado and perhaps comforted by family faces, initially consented to show a small cache on her phone and a few emails. She opened a locked box in her bedroom, an accessible wooden container with a brass clasp, and pulled out a handful of paper items, a bank statement, a photocopy of an ID, some stamped envelopes. On the surface, they were small things that corroborated her story in loose detail. It was when the agents requested a fuller handover that the scene fractured. Under casual pressure, the box revealed more than I had expected. 2 separate sets of documents with different names, an array of pre-printed application forms with the same handwriting but different signatures, and a slim spiral notebook, pages densely annotated with account numbers and routing details. The handwriting matched the signature variances we knew in the original loan file. There were photocopies of IDs with altered information, and a few business cards for shell companies. At that moment, the family's collective confusion deepened into alarm. "What is all this?" my mother whispered. Uncle Ray looked at the spiral notebook like it might bite. Jennifer's eyes narrowed, calculating, flaring between defiance and the sudden realization that the theatrical mask was slipping. I didn't gloat. There's a peculiar humility to being the architect of a legal truth in your own family. Evidence is evidence. It doesn't punish you with anything it didn't already contain. But there is also a recognition that the thing we were unearthing was larger than one loan. The artifacts in the box suggested a pattern. The agents photographed everything. They placed inventory tags on the box and its contents. They read out a basic custody statement, who had taken possession of the evidence, when, and why, and logged each item into their chain of custody notebook. That procedural language sounds mundane, but it is the backbone of any prosecution. If you cannot prove where an item was from the moment of retrieval until trial, a defense attorney will attempt to paint doubt into every step. I observed quietly as they worked, then moved to formalize my recusal. I sat at the small desk by the window, my handwriting tight and careful as I wrote a brief disclosure, relationship to the accused, summary of admissions heard, and a list of the items I had personally documented. I appended the timestamp photographs I had taken earlier and handed the packet to the lead agent. The ethics of my position demanded that I step back. I had supplied the initial observation and contemporaneous documentation. The agency, through Deputy Director Martinez, would now assign a prosecutorial team and a neutral case agent to take custody of the investigation. Before I handed off the matter entirely, I did one more practical thing, offering a factual summary to the acting federal liaison and the on-site team. I described the timeline I had reconstructed from my personal records, the date of the inquiry, the appearance of missed payments, the discrepancies in the account name, and the screenshot she had shown me. I requested that they prioritize preservation of digital artifacts, phone backups, email headers, and any lender communications that might have been saved on cloud accounts. They took notes, asked a few pointed questions, and then moved into a formal interview with my sister. There was no dramatic reading of rights at my insistence or anyone's. That comes later under Miranda when a suspect is in custody and within the precinct's control. At this stage, we were preserving options. Jennifer's cooperation, or lack thereof, would shape how quickly we could obtain lawful access to her devices. Somewhere beneath everything else sat the figure I had been reticent to make explicit. The loan, in this telling, and for the purposes of the public narrative of this case, is presented as $100,000. The documents showed that amount as a central transaction tied to the approval notice on her phone. There were larger sums hinted at in the loose papers, payments scraped off accounts, reimbursements listed to shell entities, but those would require a full forensic audit to quantify. I call that out now so anyone following can keep the central crime anchored to the title, a $100,000 loan obtained using my identity. Later, when the auditors went through bank transmissions and ledger entries, they would identify a broader pattern that, as the formal record later reflected, aggregated into a far larger total across multiple accounts, an approximate figure that would be cited in the formal audit. For now, the concrete operative number in the room was the one printed on the screenshot in Jennifer's hand. Family members drifted from the room in different directions. My mother went to the kitchen and sat like someone waiting for a verdict. My father, fists furrowed in the palms of his hands, moved outside for air. There were questions, shouts at first, then a low hum of conversation. Jennifer alternated between denial and angry justification. She said she'd meant to pay. She said the loan was to help the family, to invest, to create. Rationalizations poured like warm water into trembling cups. I watched it all as if from behind glass. There's a professional instinct that keeps you clinically present. You catalog witnesses, you mark inconsistencies, you note who had motive and who had means. You also measure pain. The betrayals that matter most are the ones that sever the places you go to muss the sheets of your life. A mother's trust is different from a bank's ledger. You can repair accounts. You cannot undo certain ruptures. Before the team left to initiate formal evidence collection and liaise with the U.S. Attorney's Office for potential charges, identity theft, bank fraud, possibly forgery, and wire fraud where the electronic transfers supported it, they made sure to give my parents the resources they needed. They provided contact information for victim assistance, explained the early stages of what would follow, and reassured them about the chain of custody for personal documents and financial records. To the family, the legal talk was a foreign tongue. To the agents, it was the scaffolding of accountability. As they packed up computer images and secured the spiral notebook in an evidence bag, I realized how quickly ordinary life can become an exhibit. The brass clasp that had once merely closed a wooden box was now metal proof that something had been hidden and then revealed. The notebook felt heavier than its size suggested. I was not the one to read Miranda rights that evening, nor did I handcuff my sister. The team's decision to pursue an on-site evidence collection rather than immediate arrest reflected a judgment call. Preserve the scene, collect evidence, ensure the file is prosecutable. Arrests are public and irreversible in consequence. They also require an evidentiary threshold. On-site admissions and the documents in the box gave us probable cause, but the formal step of placing someone in custody would be coordinated once the case team had secured digital forensics to remove any scene of doubt. Before they left, the agents read me a brief procedural statement explaining that because I was personally implicated as the aggrieved party, I would be required to recuse formally from active investigative roles and would be asked to turn over my contemporaneous notes and photographs for inclusion in the investigative file. It is a cold sort of choreography, professional ethics intersecting with personal wound. I handed over the photographs, the timestamps, the notes, and my recusal statement. I watched as the lead agent slid these items into a manila folder, sealed it, and wrote the case number across the top in black ink. The folder was a small, sober thing, but it contained everything necessary to begin a federal prosecution: admissions, corroborating documents, witness lists, and a living, breathing ledger of fraud. As the agents drove away with the evidence secured, my family remained in the house, the chairs around the dining table now oddly domestic and strangely foreign. My father sat with his head in his hands. My mother wept without sound. Jennifer sat rigid as a statue, mouthing words I could not quite hear. The house felt altered, as if the walls had absorbed and then exhaled a different atmosphere. I walked outside and stood alone on the lawn. The sky was the same, indifferent. The Mercedes was gone. A neighbor who had watched from his porch nodded at me as if to say things were as they had been. But they were not. The ledger had opened. There are manners in which one contends with this. Professionally, I would later be expected to compile formal affidavits, hand over evidence to a neutral agent, and then truly step back so the agency could pursue the investigation without the appearance of impropriety or personal motive. Emotionally, there is no such structure. You carry it. You keep your parents' shoulders from collapsing. You speak to a sister who once stood at your shoulder in childhood games and now sits riveted by a procedural reality you helped create. Even now, as the sun set and the household settled into a strained quiet, the practicalities were running in the background: cloud backups to be subpoenaed, lender communications to be preserved, and the need to coordinate with the U.S. Attorney should the facts support an indictment. None of these things is theatrical. None offers immediate solace. I made a decision that evening to let the documentation speak. That is the posture that has guided me for 2 decades: evidence over emotion. It's why I hadn't confronted her earlier, bluntly and publicly. It's why, even now, my language remained precise. Used my identity. Loan obtained. Screenshots and hard inquiries, instead of the personal litany that roared quietly in my chest. In the quiet that followed, I went back inside to be with my parents. I sat with my mother at the kitchen table and explained, in short sentences, what would come next. She wanted to know if her son would be able to undo what had been done, whether credit could be repaired, whether restitution was a reality. I told her there were mechanisms: credit freezes, fraud alerts, formal disputes, and that the investigation would aim to secure restitution, but that such financial remedy is often partial and procedural. She asked if Jennifer would go to prison. I gave her the measured answer that derives from years of prosecutorial observation. There are statutes that address identity theft and related financial crimes, and penalties can be significant. To say more would be premature until the prosecutors filed charges and the courts adjudicated them. There are moments in this business where personal and professional ethics collide. I called Deputy Director Martinez later that night to provide a full narrative and ensure that the transfer of the case would be clean. "You did the right thing," she told me, not as praise but as confirmation that process had been followed. "We'll assign a neutral agent and move the evidence through the forensic unit as soon as we can. You will have to recuse. We'll brief the U.S. Attorney." I felt a relief that was not joy. There was a relief in the fact that the machinery of justice had been set in motion, that the ledger would be reconciled, if painstakingly, by processes designed for this very moment. There was also a grief for what the motion cost our family. You cannot put an arrest or a prosecution on a dinner table and expect the china to remain intact. I went to bed that night with the taste of lemon tart still in my mouth, with the echo of my sister's laugh ricocheting in my memory, and with the manila folder sealed on my desk. The logical next steps would be bookkeeping and back-and-forth emails with a forensic accounting team, subpoenas for the lender's records, and lay witness interviews. There would, down the line, be indictments or not, plea negotiations or a trial, restitution calculations, and, ultimately, sentences. Tonight, however, the urgent thing was smaller and quieter: preserve, document, and prepare. When you are the person from whom the theft was made, You carry particular responsibilities. You hold your notes with fidelity. You do not embellish, and you do not allow the personal betrayal to drive reckless action. It is a restraint that honors the very law you are about to ask to carry out. For the family, it is an act of betrayal by one of their own. For the system, it is a fact pattern that demands attention. I slept poorly. The next morning, I began compiling a fuller chronology. I pulled together the emails, matched the approval date to the hard inquiry, and sent a secure message to the agency's forensic unit requesting expedited imaging of Jennifer's devices should the proper warrants be authorized. I noted the items in the wooden box and requested a full inventory be logged into evidence management software. I wrote a compact narrative of the dinner, placed the family's witness list alongside it, and sent the packet up the chain. The work of justice is often unromantic. It is invoices and timestamps, authenticated headers, and service of process. It is the slow knitting together of a case in which every loose end has to be tied by an evidentiary knot that no defense attorney can fray. It is methodical and unglamorous and utterly necessary. If you're intrigued by how financial crimes unfold from the inside, stick with me. I'll walk you through the full case. There are details to come that show how a ledger can be turned into a courtroom narrative, how electronic breadcrumbs can become a chain of custody, and how a family dinner can become the site where a pattern of fraud is first revealed and then legally confronted. That afternoon, as the preliminary collection files were being compiled at headquarters, I sat across from my sister at the kitchen table for one of the last times before I formally stepped away. Her face was tired. The performance was gone. There was only a human being with the look of someone who has been unmasked and is surprised to find the curtain closed. "I'll pay it back," she said, voice thin. "I'll fix it." "I don't know," I said, because at that point it wasn't entirely a question of money. It was about trust, the ledger of relationship that, once breached, is not simply reconciled by a check. She looked at me then, and for a moment I saw the girl she had once been, less guarded, less theatrical. It did not soften the facts before us. We arranged to meet with a victim assistance coordinator who came the next day to explain the procedural protections and to help my parents place fraud alerts and begin the dispute process. That was small comfort. The agents continued to work, gathering records from the lender, drafting affidavits for potential warrants, and coordinating with the U.S. Attorney's Office on next steps. My formal recusal was processed. I handed over my notes and withdrew from any substantive role in the inquiry. It is a strange surrender for someone whose life is to seek truth, to be compelled by ethics to watch while others handle the prosecution you initiated. But there would be no shortcuts. The next phase required time. Forensic imaging would take days. Audit trails would need to be followed through multiple institutions. If the prosecution would allege a pattern beyond the single $100,000 loan, if the later auditor's numbers proved larger, aggregating across accounts and victims, then it would be based on careful, documented accounting, not on the breathless claims of dinner table drama. That evening, I sat at my small kitchen table and looked at the manila folder again. It was filling up with notes and photographs, and the kind of small, precise evidence that would later be explained in a courtroom, in words that were clinical but devastating. Employer statements, bank ledgers, sequence of applications, forged signatures, and, yes, an initial admission at a family dinner. The law rests on that kind of detail. Outside, the neighborhood lights blinked on as if nothing untoward had occurred. Inside, the family's life had shifted along a fault line. I thought of all the times I'd been called unambitious or plain, and how those labels had shrouded the work I had devoted myself to. I thought of the ethics of disclosure and the cost of choosing duty over silence. Tomorrow, the agents would return with subpoenas and an evidence team. The case would expand. There would be questions about whether the ledgers pointed to additional victims, whether shell companies were involved, and whether wire transfers linked accounts across state lines. Those are matters for forensic accountants and prosecutors. Tonight, though, I lay out the first act of the ledger in my mind. The admission, the loan amount, $100,000, the screenshots, the box with its spiral notebook, and the quiet, dawning knowledge that some lines in my family's narrative could not be re-inked. I went to bed with a checklist and a prayer. Not the kind you say aloud in the precinct, the kind you reserve for late hours when the arithmetic of betrayal is a private thing. That truth would be followed, that my parents would be protected, that the law would do what it was asked to do without destroying those it sought to protect. When I closed my eyes, the image that stayed with me was small and absurd. The clean white of a porcelain plate, a smear of lemon tart on the rim, and the signature on a photocopied ID tucked into a wooden box. Evidence, like memory, insists on staying. The days that followed moved with the slow, precise tempo that investigative work demands. For all the family drama that had erupted at the table, the agents and the prosecutors treated the file like a machine that needed gentle, exacting oiling. Nuala was hurried without documentation. No step was skipped if it would later be a hole the defense could exploit. The forensic unit began with the obvious, imaging devices. The agents returned with search warrants, issued based on the contemporaneous admissions, the physical documents recovered from the wooden box, and the digital artifacts I had photographed at the table. Warrants are not ornaments. They are permission slips signed by a judge that allow us to mirror a device exactly as it existed at a moment in time. The technicians worked in a small, quiet lab with Faraday bags and write blockers, capturing bit-for-bit copies of phones, laptops, and compact cloud caches. I watched them move like surgeons, methodical and unhurried. The work was clinical. Hash values, timestamps, metadata. It was also profoundly revealing. Deleted messages surfaced. Backups revealed synchronizations that Jennifer had not mentioned. Files she thought wiped lingered in shadow copies and in auto-synced folders. The bank complied with a subpoena, producing account statements, wire logs, and application files. What the lender provided was a paper trail that rarely lies. An application packet, the name listed as reference, routing numbers, and a sequence of transfers that, when mapped, showed the direction of funds. The forensic accountant assigned to the file, an unremarkable woman with a blunt haircut and an appetite for ledgers, began to narrate the financial life of the scheme. Her voice in briefing was steady. She walked us through reconciliations, explained how temporary accounts were used to route proceeds, and showed how payments were shuffled across accounts to create the impression of activity where none existed. The auditors identified a pattern. The $100,000 loan that had appeared on Jennifer's approval screenshot was not an isolated incident in terms of behavior. Across the accounts captured in the evidence, there were transactions and applications that suggested a broader mode of operation. When the numbers were aggregated, the audit later documented losses approaching the low hundreds of thousands, an approximate total that would later be reflected in formal exhibits. For this narrative, the central transaction remains the $100,000 loan, which prompted the operational response that night at the dinner table. The auditor's later work provided context and scale. My formal recusal was honored at every step. I provided my contemporaneous notes and photographed screens to the neutral case agent, then stepped into a support role for my parents. Protocol is not performative. It protects the integrity of the case and, in my situation, shields it from claims of vendetta. I would be a witness, not a handler. That separation felt necessary and, in truth, lonely. I surrendered the adrenaline of leading a case to maintain its legitimacy. Investigative interviews began in earnest. Witnesses were interviewed under recorded conditions. My parents, Uncle Ray, aunt, and a few neighbors who had seen Jennifer's comings and goings. Jennifer was interviewed by a team assigned from the field office. At first she offered narratives of convenience, temporary bridges, intended repayments, entrepreneurial necessity. When a subject offers a justification, an investigator listens not for dramatic confession, but for contradictions that will help frame the timeline. Jennifer's story shifted in small ways. Dates moved, names omitted. Where her phone contained a casual brag, her recorded statements sought to minimize culpability. The defense, once retained, did the work defense attorneys do: search motions, challenges to probable cause, and requests for the production of grand jury materials. David Morrison entered the file as Jennifer's counsel. He is a capable lawyer, careful and diligent. He filed motions that a defense lawyer must file, arguing lack of intent, claimed confusion about shared accounts, and, in one filing, questioned the sufficiency of the chain of custody for certain images. Those motions required us to be equally meticulous in our documentation. The chain of custody logs, the lab notebooks with the hash values, the timestamps on my photographs, every piece of bureaucratic detail became a fortress against those challenges. A grand jury convened. The U.S. Attorney's Office considered the evidence and drafted an indictment listing counts consistent with the paper trail: identity theft, bank fraud, forgery, and wire fraud. The indictment was not theatrical in language. It was a recitation of facts tied to dates, account numbers, and transfers. Indictments build on things we can prove beyond a reasonable doubt, piece by piece. That is why the initial admission at the dinner table, useful as it was, needed to be supported by a mass of corroborating documentation. The grand jury returned an indictment, and an arrest warrant followed. The day of the arrest arrived on a weekday in late autumn. The light was thin, the sort of gray that flattens color and makes faces seem further away. I watched from a distance because ethical walls require it. I had no role in operational execution. The neutral team had discussed logistics, risk, and the desire to avoid spectacle. Arrests are not performances. They are necessary steps in a legal process that, when mishandled, can unravel a case. They moved early and quietly. Plainclothes agents approached Jennifer's residence in 2 unmarked vehicles. A liaison from the local field office accompanied Deputy Director Martinez, who had come to oversee the operation. Her presence was not for show. It was for chain of command clarity. She arrived with the same steady, efficient manner she brings to briefings. No dramatic flourish, only the authority that follows years of handling sensitive matters. The agents knocked and announced themselves. Jennifer opened the door, as she had done 100 times before in different guises. The tone was calm when an agent stated that she was under arrest on an indictment issued by a federal grand jury. The reading of rights followed in the formal cadence trained into us, clear, unhurried, and documented. She was handcuffed, escorted from the house, and placed into custody. The scene was subdued. There were no shouts, no cinematic struggle. In that moment, the gravity of consequence replaced the theatrical behavior that had once served her. At the field office, the booking process unfolded. Photographs, fingerprinting, and the formal reading into custody. Jennifer had the opportunity to make a first call, and her defense counsel appeared shortly thereafter. One of the more difficult ethical moments for me was seeing her processed as a defendant, rather than the sister who once cut my sandwiches in the kitchen. I had been the person wronged. Now she was the person the law accused. The law requires us to be precise about those roles, because imprecision allows narratives to become weaponized. Pretrial proceedings moved along the statutory arc. There was an arraignment where the charges were read, and she pleaded not guilty. In the weeks that followed, the exchange of discovery produced hundreds of pages: bank records, email headers, application PDFs, lab reports, and the spiral notebook I had first seen in the wooden box. Forensic accountants testified in proffers and declarations, explaining the flow of funds and clarifying how electronic transfers could be traced. Metadata experts explained email headers and IP logs in plain language, showing how certain transactions and communications were tied to specific devices and accounts. The defense attempted to frame arguments about consent and misunderstanding. David Morrison sought to depict certain entries as clerical errors or misattributions, to argue that the ledger could be interpreted differently. These are legitimate defenses. A prosecutor must be able to meet them with documentation. The prosecution's response was simple in method and devastating in accumulation. Timelines that matched inquiry, dates to application timestamps, photographs of the screenshot, the handbooks of the lender showing approval processes, and the spiral notebook linking account numbers to transfers. We presented ecumenical threads of evidence that, taken individually, might raise questions, but taken together formed a contiguous story. We negotiated. Plea negotiations are a theater of utility. Prosecutors hope for admissions that conserve resources and offer restorative outcomes where fitting. Defense counsel seeks lesser penalties and alternatives where conviction looks likely. Jennifer's team explored pleas, but she ultimately chose to proceed to trial. Whether that choice arose from hubris, hope, or counsel is not a question I will answer here. What matters is that the government prepared a trial where those documentary threads could be placed before a jury, and where witnesses could account for the movement of money and the provenance of signatures. The trial was scheduled in the federal courthouse. Courtroom days are long. The prosecutor's opening statement laid out a sequence rooted in the dinner admission, the lender's approvals for a $100,000 loan, and the subsequent paper trail that connected the application to accounts that the auditors traced. The defense's opening statement attempted to humanize Jennifer, to cast doubt on motive, and to raise the possibility of benign explanations. Jurors listened in a way that made you aware of breath in the room. Their role is to weigh evidence against doubt, not to be impressed by narrative. Witnesses took the stand. I testified to what I had heard and what I had documented, that, at a family gathering, Jennifer had admitted to using my name to secure a loan for $100,000. My testimony was measured, precise, and supported by my contemporaneous notes submitted as evidence. The forensic accountant testified with ledgers and annotated spreadsheets. The bank operations manager explained how application materials are processed and how synthetic or fraudulent IDs are flagged. A digital forensics examiner demonstrated how deleted messages could be recovered and how photo metadata established the provenance of images. Jennifer testified in her defense. She appeared smaller in the witness box than she had seemed at family gatherings. On cross-examination, she was asked about the spiral notebook, the photocopied IDs, the email threads that seemed to coordinate the movement of funds. Those documents were not rhetorical. They were concrete. The jury heard the dinner room recording of the admission in a limited, admissible excerpt, and they saw the screenshot. The defense emphasized context and intent. The prosecution emphasized patterns and corroboration. The jury deliberated. Deliberations are private, but their rhythm often reveals something. A volley of notes, the return of a juror to request a readback of testimony, a question about a specific ledger entry. After several hours, the verdict was returned, guilty on counts of identity theft, bank fraud, and related charges. The courtroom exhaled with the kind of silence that brings one back to the fact that the law has spoken through a process, not from passion. Sentencing proceeded on a calendar date weeks later. Sentencing is part accountability and part judiciary assessment, a calibrated weighing of offense and offender. The prosecution submitted a sentencing memorandum highlighting the pattern of conduct, the financial harm, and the breach of trust within a family as aggravating factors. The defense urged mitigation, personal history, expressions of remorse, the argument that incarceration would not repair what had been done. The judge considered the advisory federal sentencing guidelines and the presentence report prepared by probation. The court imposed a sentence of 8 years incarceration. It also ordered restitution and conditions of supervised release following incarceration. The sentencing judge spoke to the harm inflicted, particularly on victims whose credit and finances had been compromised, and to the societal interest in deterrence. The exact restitution figure was formalized in the court records and set through the post-conviction accounting process. The court's order required that Jennifer make the financial remediation ordered by the court as part of the judgment. There was no cinematic gloating in the courtroom. The judge's words were sober. The mechanics of sentencing do not erase the human cost on either side. A sister going to prison, parents coping with public humiliation, a family fractured along lines that may prove difficult to mend. I left the courthouse with a ledger in my mind, not of numbers, but of consequences. In the months that followed, the administrative machinery kept moving. Appeals were considered in counsel's offices and addressed through the appellate process as allowed by law. Probation officers worked on restitution schedules. The U.S. Attorney's Office coordinated with victims' assistance units to ensure that the family and other impacted parties received resources to correct credit reports and document losses. For my parents, the practical help mattered. Steps to initiate credit freezes, instructions to file identity theft affidavits with the credit bureaus, and guidance on monitoring accounts. The presence of victim assistance officers was not a balm for grief, but it created pathways for repair. The family's interior life shifted in ways that money and law could not fully account for. My mother folded into quiet routines and sometimes asked if she had failed, questions that have no forensic answers. My father retreated into the garden, both out of habit and because it is where men in our family have always found a place to think. Uncle Ray visited less frequently. Friends picked sides, and the small rituals of holiday gatherings were halted, tentative, or relocated. My sister's actions did what betrayal often does. It broke a line of small courtesies that had been built over decades. Relationships that had seemed fixed were, for reasons both petty and profound, suddenly conditional. I received letters from Jennifer in the early months of her sentence, careful, apologetic notes that attempted to stitch a narrative of regret. I read them not as evidence, but as the human attempts they were. I responded, with limits, through counsel, because there are boundaries set by both law and personal ethics. Some family members wanted no contact at all. Others, silently grieving, oscillated between anger and a desire to understand. Those are private reckonings. The law adjudicated culpability and imposed punishment. It could not direct forgiveness or chart the slow arc of familial repair. Professionally, the case closed in the way these cases often do: a docket entry, a sealed folder of exhibits, and an archival file that might someday be requested for training. The forensic audit that began as a means to establish the reach of the scheme produced a report that prosecutors used in sentencing and in restitution calculations. It documented the financial movements across accounts and the collateral impact on other victims, people who had nothing to do with our family and yet felt the sting of an orchestrated fraud. The totality of loss the auditors recorded was a sobering counterpoint to the intimacy of the dinner room confession. The work left a mark on me that neither paperwork nor courtroom could fully translate. There is a professional clarity that comes from seeing process work, evidence collected properly, a neutral agent conducting operations, the grand jury returning an indictment based on adequate proof. That clarity is the apparatus of accountability. But there is also a private disquiet that none of that process resolves. I had, by necessity and duty, converted domestic betrayal into prosecutable fact. The law did what it does. It established responsibility and consequences. My family, though, was left to navigate the moral fallout and the long, awkward path of whatever reconciliation might someday occur. I reflected on the odd camouflage I had cultivated for years. Being underestimated was a shield and a tool. It allowed me to move in certain spaces without attracting notice. That invisibility had enabled me to work complex investigations in the world. At home, it had allowed others to remain at ease. But that same camouflage meant I carried the burden of intelligence and consequence alone when the family table revealed its fracture. The advantage of being underestimated is double-edged. It affords operational surprise, but can exact a personal cost when secrecy and duty intersect with those you love. When people ask whether I regret the decision to involve the federal system, whether a private resolution would have been preferable, I answer with the same professional candor I have offered throughout this narrative. Identity theft is not merely a private dispute. It has public consequences. Loans of significant amounts, forged signatures, and the movement of funds across accounts create tangible harm to others. Restitution can ameliorate but not erase the credit hits, the anxiety, or the reputational damage. The criminal justice system existed, in part, to respond to precisely these transgressions in a manner that is measured, documented, and accountable. There were moments when my role as a federal agent and as a brother collided in ways that left no tidy resolution. I visited the probation office to review restitution schedules. I sat silently as a probation officer explained the mechanics of payments and the calendar for reporting. I fielded calls from family members who were angry at the visibility the case had brought into our lives. I sat with my mother while she called her bank repeatedly and listened to her voice tremble and then steady as she worked through the steps the agents had recommended. Small practical actions, credit freezes, fraud alerts, dispute forms, were the mechanics of recovery. They were also thin salves on a wound that required emotional tending. In the quiet after conviction and sentencing, I thought about what it means to choose duty over discretion when the person who broke the law is someone whose younger self you played with on rainy afternoons. I do not mean to suggest that family loyalty should eclipse justice. There are times when healing requires accountability. My choice to document rather than denounce in a moment of anger was a deliberate one. I wanted truth, not spectacle. I wanted a process that could be aired in a court of law rather than an argument at a table that might dissolve into recrimination and secrecy. This case also reinforced my conviction about the tools we give victims. The assistance my parents received, victim coordinators, counseling referrals, and guidance on repairing credit was essential. Many victims of identity theft feel bewildered and alone. Institutional supports do not fix the past, but they provide a navigable path forward. For anyone watching who is dealing with identity theft or fraud, the first practical steps are straightforward. Place fraud alerts, contact creditors, obtain copies of credit reports, and report the crime to the appropriate agencies. There are specialists and hotlines designed to help. The process is bureaucratic but survivable. There is an afterlife to these matters that cannot be measured in sentences alone. Jennifer's incarceration imposed physical distance, but it did not and could not resolve the emotional geometry of our family. Time does not guarantee reconciliation. It can create space for perspectives to change and wounds to mature. Whether that occurs in our household,